I've been caught, but I'm keeping on check. And I've been taught, but I'm keeping on check.
Good afternoon, good evening. This is Dove Tusman, and you're on Equal Footing again. Tonight is a second part of a two-part series around this complex and sometimes controversial world of the legal representation of children and the guardianship process. They're not exactly one and the same, of people that are under 18 in the courts. There's lots of topics we could cover when it comes to legal guardianship. It will probably get to in another show around guardianship of seniors and guardianship of people that are incapacitated due to mental health issues and other situations. But we've been talking last week and now this week about kids in the courtroom and how state by state this is handled. You know, it's something that if it hasn't touched you in your life, it's probably touched someone close to you. In nearly every disputed divorce, custody battles, for example, you often have this be the case. Sometimes children are wards of a state system for their care, in the foster care system, for example. And how do we as a society handle the legal advocacy for that child's right in the courtroom, especially when adults around them don't agree? It's murky, and we're doing our best to grapple with it as a society. Last week, we heard from a parent advocate who I think was very brave to be on the show and talk about the confusion that her 7-year-old daughter was experiencing in an active custody battle where she was assigned a lawyer by a judge in New York State, and that lawyer's going and speaking to her, pulling her out of classes at school and talking to her about what her preferences are around custody and so forth, something that's very confusing for a 7-year-old and traumatizing to her and probably both parents to some degree. And we've got the parents' perspective on what doesn't work from her perspective in the system. Maybe she's listening now. Maybe she'll call into this show. We got a lot of texts, comments, and questions during last week's show also from other parents who have gone through this process of their child being assigned a guardian ad litem. We're going to get to what that means in a moment. Or a lawyer. They're not always one and the same to represent that child's interest in the court apart from the parent. It's a topic, though, that deserves to be looked at from the other perspective, as we try to do, we endeavor to do on this show both sides of the coin. And tonight we're joined by two esteemed professionals who work with children in the capacity of a lawyer and a social worker, respectively, and spend a lot of time thinking about these issues and doing their best to represent child's interests in difficult and often disputed situations. Our first guest is Wayne Morrison, and Wayne is calling in from the Atlanta, Georgia area, and he represents clients in all aspects of family law, including pre- and post-nuptial agreements, divorces, custody actions, contempt actions, etc. And Wayne focuses on complex matrimonial matters and custody disputes in particular. He's frequently appointed by courts to serve as a guardian ad litem, where he assists the court and parties in reaching decisions concerning the best interests of children. He represents clients, many of them children, in all of the greater Atlanta metropolitan counties. And Wayne also serves as a mediator. He's a frequent writer and speaker on topics related to family law, including the intersection of family law and fiduciary law, and the roles of experts, like guardians ad litem, in family law cases. He's recognized as a super lawyer in the area of family law by Atlanta Magazine. He's received a number of other accolades. Wayne received his Juris Doctor from the University of Georgia in 1996, and prior to law school he attended Virginia Tech, where he got a Bachelor's of Science degree in finance. He lives in Cobb County with his wife Susan, their 4 children and 2 dogs, fellow dog lover. And he's also active in his community, coaching sports and teaching religious education classes. Wayne is of counsel at Kessler and Soleimani. I hope I pronounced that right. And we'll put in the show notes how you can reach Wayne if you're interested in talking to him, either in terms of the subject matter or specifically as a prospective counsel. So, Wayne, thanks for being on Equal Footing.
Of course. Thank you for having me.
Wayne, you are joined by a wonderful companion here in the program, Marion Spencer, and Marion is an adjunct professor at Long Island University. She holds various degrees, including a Master's of Social Work from Fordham University and a Master's in Public Health from the University of Florida. She's also completing a PhD in Health Sciences from Nova Southeastern University. Professor Spencer's full-time employment, aside from her teaching duties, has included managing an intensive mental health program in Queens, New York, as well as providing mental health treatment to adults with severe mental illness. And she's also managed a program for children with behavioral issues who are actively suicidal. She's referred them as well for long-term outpatient treatment, has been involved in those treatment plans. And Professor Spencer also has worked for 8 years as a foster care social worker, providing services to children and families who are in the foster care system. And Professor Spencer brings the social worker perspective and has experienced the guardian ad litem dynamic both with children as well as special needs adults. So, Professor Spencer, welcome to Equal Footing.
Okay, thank you. Good night. Great to be here.
So, Wayne and Professor Spencer, Marion, can you guys, let's start with you, Wayne, by helping the audience here understand what is this concept of guardian ad litem? You know, last week I pronounced it incorrectly. I said guardian ad litem. So what is this, and why should people care?
So first of all, I want to be clear. I am not the child's lawyer. I am not their advocate as a guardian ad litem. No guardian ad litem is the child's attorney. Okay, an attorney representing a client has an obligation to zealously represent what their client wants. A guardian ad litem acts as a fact finder. They are the court's expert, and their role is to gather information and to assist the court and the parties in reaching an outcome that is in the best interest of their children. So what a child wants is something, depending on the age of the child, that is taken into consideration, but it is not something that necessarily drives the guardian's recommendation or the guardian ad litem's work.
It's really important that you make that distinction. Last week in the program, as a father of a 9-year-old, soon to be 10-year-old, I was trying to imagine if an adult, particularly a lawyer whose profession is to persuade, was asking my 9-year-old, whether she would like to, for example, have vegetables with dinner, and I'm pretty sure in many cases she'd say no, but that doesn't mean she shouldn't have vegetables with dinner. So that distinction between advocating for the child's wants but actually providing a kind of quote-unquote impartial role for the court is really important, I think, for listeners to understand. Did I get that right? It's a very layperson's way to put it.
Yes, you were exactly correct. I don't get to make decisions, right? The guardian ad litem does not make decisions. The guardian ad litem will prepare a written report or a verbal report. We're subject at trial to be cross-examined. The judge listens to us, and really, when it's used properly, the guardian ad litem has time to devote to a case to learn more and to better assist both the parties, the child, and the court in reaching a conclusion that is best for the child.
Now, before we get to the social worker and psychologist perspective with you, Professor Spencer, is what you're describing particular to the state of Georgia? I know these rules vary a lot state by state, or do all states have this concept of the guardian ad litem and the legal representative of the child being different?
So we do have some states in the Northeast. I believe New York is one. We can go across to Illinois. There's another state, not in the Northeast, but that they have a concept where they have attorneys that are appointed to represent the children's wishes. and that is a very, very different thing. And they are not called guardian ad litems. They are child representatives, and they serve in an attorney-type role in the cases in which they're appointed. So that is different. The guardian, universally, and I believe the American Bar Association has something along these same lines, is the guardian ad litem is the court's expert. They are a neutral, and they are to help the parties and the court find what is best for the children.
Okay, we're gonna turn to you, Professor Spencer. This is really complex, state by state. One of the things that we came across last week in the show was the fact that only 4 states of the 50 states actually require the guardian to explicitly consult with a child psychologist or a social worker or someone else that has a different skill set than the guardian ad litem might bring. In your experience, and you're of course working in New York State, as I understand it, how does the social worker and the child's guardian interact? Are they one and the same in New York? How do you interact with the lawyer? Help us sort through who's representing the child's interests.
Well, oftentimes for the social worker, we bring a different point of view because most times we have seen the child like numerous times, inquiring what's happening in the days in and days out of the child, making sure that the child has everything that they need, and even living at home, what's in the best interest. So we often even go out in the field, go to the school, inquire about like the medical piece to make sure that the child is up to date with their medical and everything. So we often investigate everything. We go to the home and make sure, the child has like appropriate sleeping environment or everything is doing well in the home. But we are also different from the guardian ad litem because we can also bring back a written report as to the findings that we have when we go out to see the child, and also oftentimes we may bring back what the child may have said, or in our investigation and interviewing of the child, what the child's recommendation or what the wants are. So all of this, it comes together with the fact-finding because, again, with the guardian ad litem, they're also doing their own fact-finding to find out, okay, what is the best interest of the child? Where is the best place for the child to be, whether it's at home with the mom or dad or another relative or in the foster care system, like a foster parent or something. So everyone in their own profession is meeting with the client to see what is the best interest of the child. That's the ultimate goal. And we bring our own findings and we go to court and everyone presents their case, the mom's attorney, the father's attorney, the state, which here in New York is New York City Children's Services. So everyone has their own attorney and it's presented to the judge and then the judge makes a finding.
Right. We're getting a little bit of echo here in the line. Not sure what's going on. Okay. So, Professor Spencer, thank you for outlining that for us. When we come back after our first break, I want to hit you guys with a couple of the texts that we got from parents last week, because the way the system should work, it doesn't seem to be the way the system actually does work, at least in certain cases. You're on equal footing, and we're talking about the guardian ad litem system, and also, they're not the same thing, but also the representation, the legal representation of children in court, particularly in custody battles and in situations that can be very difficult emotionally and psychologically for the child. Participate in the discussion. Give us your perspective, your personal experience. You can call in. When you call, you can say your real name or speak anonymously. Either way, whatever you feel safe with. The number to call is 718-303-9090. That's 718-303-9090. And if you feel more comfortable not hearing your own voice on the air and you want to text in a question or comment, feel free to do so. We got a lot last week. 917-428-4062 is the number to text, or you can even WhatsApp a question or comment. Again, 917-428-4062. We'll be right back on Equal Footing.
All that I say, you always say more. I can't keep up with your turning tables under your thumb. I can't breathe.
Let's talk about one of our sponsors for a second here in Equal Footing. Great company doing great things. DocuVax. Check it out. You can download the app on your iPhone or Android phone at DocuVax. That's DocuVax. Or you can go to DocuVax.com. DocuVax gives you the power to organize and validate your medical records on your own terms. Your medical records, immunization records, serology reports, x-rays, etc., they don't belong to your doctor. They don't belong to your insurance company. They certainly don't belong to the government. They belong to you. And the way you share them, the way you do that with a new school, with a new employer, even to get into a restaurant these days, you often have to share your immunization status, should be under your own terms. Many states are implementing programs where you have to show, for example, your COVID vaccine status, and you can do that using your own medical locker profile at DocuVax. You can share the information in your medical locker using a proprietary QR code-based system that only reveals exactly what you want to reveal. You don't have to show someone at a restaurant or your birthday, for example. You don't have to do that like the Excelsior program makes you do in New York. DocuVax is recognized at the state level as a way to validate your immunization and other records. And the best part is if you sign up at DocuVax, medical professionals are on call for you 24 hours a day to validate. Those are doctors and nurses to validate your vaccine records, your blood tests, or anything else in your locker. So put an end to worrying if you or someone you care about is up to date on a particular vaccine, a blood test, or even an important preventative screening like for colorectal or breast cancer, for example. Take control of your medical file. Sign up at DocuVax.com or through the app on your smartphone, DocuVax. For as little as $6.99 per month, you can privately access all of your medical records from a secure, HIPAA-compliant digital storage facility. And if you run a small business or an organization, like you're part of, like, for example, a university or a church organization, you can get group discounts by sponsoring individuals. The data remains the property of the individual subscriber, but you can sponsor and pay for others' memberships with group discounts, especially if you mention that you heard about DocuVax on Equal Footing. You can call 833-859-1933 for those group discounts to sign up as an organization. That's 833-859-1933. Operators are standing by. Take control of your medical file.
I've been caught, but I'm keeping on to.
All right, you're back on Equal Footing. We somewhat tongue-in-cheek called tonight's program in some of our social media promotion, Shh, the adults are speaking. And the reason we called it that is because this program is about when adults represent children. They do their best to represent the children's interests in court as best as they can, either as a guardian. The term of art is a legal guardian, a guardian ad litem, or as a lawyer in a court proceeding. But we don't always get it right. We never get it right. We never get it right always, I should say, as parents, and we can't expect the same either in the legal system. Professor Spencer and Wayne Morrison, I want to read you, if I can, a text from our program last week where we were hearing from parents. And granted, this is in New York, but hopefully, maybe starting with you, Wayne, you can reflect on how the system could be better and where there are deficiencies. This is someone who asked her name not to be said on the radio, but she said that the subject matter was killing her. That it was really, I guess, what she meant by that is causing her emotional distress. She says, my experience in New York was brief, but for now I can say that the child appointed to my 10-year-old daughter spent very little time with my child. It seemed to me that she did not have any mental health background or background in violence or different types of abuse or any specialization that was relevant in her case. She did not reach out to any of my child's providers or teachers, therapists, etc. She just let the conversation between her and a young child take precedence without any neutral advisors that are directly involved in my daughter's life. I was not at all impressed. I was hoping my child's lawyer would be my child's voice, a voice of reason, a voice of protection. That's a voice she doesn't have. So it goes on, but this was heartbreaking as a parent to read. Wayne, how typical is this? Obviously, I'm sure your heart breaks these situations as well. You wouldn't have gone into the field, but does the system always work?
Well, no system works 100% of the time. I would have questions about the investigation and the work that is being described. So what should happen is that the guardian ad litem should interview the parents separately, right? I would interview both parents individually, and then I would observe the children typically with both parents separately, right? So I'd start maybe with mom, and she would come in my office. I'd interview with her, interview them with dad, and then maybe go to mom's house and watch mom with the child, watch dad with the child later. And there's no set order to that. But additionally, I am getting information and materials. I'm talking with teachers, administrators at the schools. I'm asking for medical records. A guardian has a duty to do a full investigation. And if any guardian only talked to the child, cross-examination at a trial would be somewhat ugly and uncomfortable for that guardian, I would think.
Now, Wayne, sorry for the interruption. One of the pieces that I was tasked with researching before today's show was an American Bar Association study on problems in the guardian ad litem system, and a lot of it had to do with the lack of rules. So very few states actually mandate, as I understand, although I'm sure it's best practice.
Right.
There are very few states, that, as I understand it, that mandate the guardian ad litem to consult with therapists or social workers or others that might be in the child's life. Is that wrong? Is the ABA onto something there?
No, that is correct. What we have to take a look at is how we get a guardian in a specific case. Okay, the guardian is going to be appointed by the judge. Now, that may be a person, usually an attorney, but not always an attorney, that maybe the two lawyers agree on, but it's going to be someone that the judge has confidence in.
Sorry, Wayne, when you say the two lawyers, that would be the advocate for the two parents in a custody battle.
That is absolutely correct. So they may, I have two cases right now where I'm the guardian, and the lawyers on the different sides, lawyer representing mom, lawyer representing dad, 4 different lawyers with the two cases, they agreed on me to go and do the investigation. The judge agreed. An order was signed. The order gives me the authority to get confidential health information from doctors, to get all those things.
Sorry, Wayne, did the judge recommend you and they approved you, or did the two parents who are obviously adversaries in the custody proceeding, did they find you together? How did they get to you?
The lawyers representing the parents. And what typically would happen is one lawyer would call the other. They would see if they could agree. When I'm representing one of the parents, I would usually provide the other side three names. These are 3 attorneys who I've worked with as guardian ad litems. Do any of these people sound agreeable to you?
Okay.
Now, sometimes the parties don't agree, and then the judge appoints someone. But you hit on a key term when you said adversarial, adversaries. The guardian doesn't really doesn't have anyone advocating for them. So they're up there and they're going to testify if the case goes to trial. And one of those lawyers is probably not going to be entirely happy with what the guardian recommends.
Sure.
And there's a time where both lawyers are not happy with part of the recommendations, right? No one's going to probably get everything their client wants. and the guardian is going to be cross-examined. Did you talk to the teachers? When did you talk to the teachers? Did you get medical records? Did you contact DFACS? So if a guardian does not do a thorough investigation, they are probably not going to be listened to by the judge because they're going to be left bruised and bloodied at the end of the trial.
So if you would allow me to interpret this as a layperson, are you saying the system is kind of self-regulating? Because if the guardian, even if they're not mandated to consult with the school social worker or a therapist or a coach or other people in the child's life, they're going to get torn apart in cross-examination. So they're not mandated to do it, but if they don't do it, they're not going to do their job well?
So in an ideal world, yes, it is self-regulated. And I am saying they will get bruised and bloodied. It would be naive to think that a judge is not going to rely on the guardian a great deal. They appointed the guardian. The guardian is their expert. So if one side at some point during the process loses confidence in the guardian, they can file a motion to have that guardian removed and replaced.
Right.
And they can present evidence about that.
So we're going to take another break in a minute, but we've been talking about the problems in the system last week and touched on it now in terms of guardianship of minors and legal representation of minors in divorce battles and custody battles. But there's a different perspective, and that's where maybe parents are often, I guess you're helping explain why I've gotten so many texts, even as we started this show, from parents who have been dissatisfied because by definition you're not going to probably please at least one, if not both sides, when you're impartial. So that's helping to explain something to me. But let's turn it around with you, Professor Spencer, where you're working where there isn't an adversarial situation with parents, but rather the state is the actor, and the child is effectively a ward of the state in the foster care system, for example. And here, we're going to put this in the show notes, there's a really good article by Catherine Federle and Daniel Gondobsky. It's gotten a lot of distribution, called The Curious Case of the Guardian Ad Litem. And it talks about how in various state level department, the foster care system often governed by like a DCF, Department of Children and Families, and state by state these departments have different names, but how often the kids don't know that they have a lawyer. In fact, there's a testimony in the article for someone who's become an advocate for better relations between foster children and guardians, who says, I'm not going to quote the whole thing in the interest of time, but it says, I was in the Department of Children and Families under foster care since I was 12 years old, but I didn't even know that I had a lawyer that was assigned and was representing me until I was 18 years old. That was when I found, and the reason I found out was that was when I found out that I no longer had that lawyer. So talk to us a little bit about that dynamic, where it isn't the child in a custody battle with their two adversarial parents, but where you're involved, Professor, with a child as their guardian, perhaps in terms of their welfare being guarded by the state.
Yes. So I actually wanted to even speak about the previous question where the mom wrote last week about her her 12-year-old only met with the guardian for 5 minutes. Normally, on a typical case, and I've said I've worked with guardian ad litem for approximately 8 years. The guardian ad litem that I've worked with, they have gone to the schools, they have gathered medical records, they have gone to the homes, gone to the foster homes, invited the child to come to their offices to meet with them. So the experience that I've had has been very positive. And I've also had cases where the guardian ad litem is able to hear my concerns that I've had, even like when I go to foster homes, and the concern that I have where it may not be the best placement for the child. And the guardian, the guardian ad litem also did their own investigation and agreed with me.
Mm-hmm.
and assist with getting the child moved to another location or a different foster home. These are cases where
and that may run and that may run. Sorry for the interruption, Professor. By the way, we're getting some feedback. It may be because you're on a headset. You might want to transfer to a handset. But that brings up what Wayne said earlier about how the guardian ad litem is not maybe a lawyer by training, but is not acting bound by the duties of loyalty and advocacy that a lawyer would have, where you just go with your client's express preferences. As I understand it, a guardian may go against the preferences of the ward, of the person they're guarding, if they think it's in the best interest. That's kind of part of their role, as if I understand it correctly.
Yes. They have, their duty is to act in the best interest of the child. Yes.
So we're going to go to a break. Let me ask you just point blank, Professor Spencer, in your many years of working in the foster system and interacting with guardians ad litem, if you just had to say a percentage of the time that you think, in retrospect, they get it right in the foster care system, as it pertains to the major decisions of their ward, of the child they're guarding, what percentage do you think of the time they get it mostly right?
I would say, it's hard. It's hard. The percentage is hard to say. Can I give a percentage?
I mean, is it 9 out of 10 or is it 5 out of 10?
It's maybe 6 out of 10.
Okay. And to get that 6, one more question before I go to break, because I can't help myself. To get that 6 out of 10 to a 9 out of 10, what do we need to do? Is it better regulations or training for those people, or is it just unavoidable that it's just the way that, I mean, just as in parenting we make mistakes? Do you think we can get that 6 out of 10 up to 9 out of 10?
Yes, we can, but I think it comes with working with professionals who actually know about children's health, children's mental health, the best interest of the child, and not just like ask questions to the child, okay, do you prefer mom or dad? I think more intensive training would help for people to understand and even learn how to even ask questions to children more appropriately and age-appropriate questions. So with the appropriate training, I think we can get there.
That's what's so scary, and one of the reasons why I wanted to do this program as a parent of a young child is I know how especially really sensitive and kind children can often try to please everyone. And when you have two parents that are pitted against each other, they'll often toggle between trying to please both parents and whoever's talking to them at that given time. So for me, it's so scary to even think of, no matter how well trained the person, it just seems very perilous to say to a child, okay, your parents are fighting, where do you think you should live? Where do you want to go to school? I mean, I would imagine you could get different responses depending on who's asking, what time of the day, and what the child thinks the consequence is of their answer. We'll come right back talking to Professor Marion Spencer, accomplished lawyer Wayne Morrison, talking about this complicated dynamic of representing children in court, both as guardians, as lawyers, as social workers. How do we do this better? We'll be back on Equal Footing.
Equal Footing with Dove Tusman is sponsored by MDCS Dermatology, your experts in skincare. With 2 Manhattan locations and 4 offices in Long Island, including Plainview and Commack, the dermatologists and skincare surgeons at MDCS are proud to be affiliated with the Albert Einstein College of Medicine and New York Presbyterian Hospital. So schedule your next skin exam in one of MDCS's convenient New York area locations. To make an appointment, go to www.mdcs.live or call 212-661-DERM. That's 212-661-3376. You can even schedule a virtual video visit with MDCS's board-certified dermatologists from the comfort and safety of your own home. So go to www.mdcs.live or call 212-661-3376. And don't forget to mention Equal Footing for 15% off all cosmetic procedures.
I've been caught, but I'm keeping on to.
All Hi, you're back on Equal Footing. My name is Dove Tusman, and I'm joined by Wayne Morrison and Professor Marion Spencer. Wayne is a family law attorney, works in complex divorce and custody battles. Professor Spencer is a adjunct professor at Long Island University and has worked as a social worker for many years, dealing with children's issues, with the mental health context and the foster care system. And if you're listening and wondering why this topic matters to you, you ought to care. If you care about kids, if you're a parent that has the prospect of going through, God forbid, a divorce proceeding, or you have friends that have gone through this touches many more of us than you'd think. I think many people, when they go through a custody battle and a divorce, Wayne, I'd be curious whether you think I'm saying this is a truthful statement, tend to be very private about it, even with their closest friends. It can be so painful, so traumatizing, that you might not know that that friend of yours going through that divorce process actually does have a guardian ad litem assigned for their child, or a lawyer in certain states advocating for their child in court. And it's complex. We heard last week from a mother who was on the program who told us about a lawyer taking her kid out of school, her daughter at 7 years old, asking her where she wanted to live, asking her preferences in the context of the legal proceeding. It's hard. Wayne, in researching, I went down a rabbit hole in the research process for this show, and I was trying to figure out where the guardian ad litem concept comes from. And my understanding is this goes back like 2,000 years, if not more, to Roman law. This concept of someone taking over the decisions of another person. And it's ingrained. It makes sense to me because I've always understood that there are guardians in legal contexts. Maybe in my case, because I have a younger brother who has severe mental health challenges, and he's had guardianship dynamics with the state. But I think you step back, it isn't totally obvious. Like, why doesn't the judge in a divorce proceeding, for example, simply hear both parents' sides, ask social workers to testify, talk to psychologists, and make an impartial decision, which would seem to be more in line with so many disputes in court? Why, in this case, do the courts generally assign an advocate or a custodian? They're not the same thing. We've talked about that, for the child.
Well, we only have an hour to start with. So, but what I will say is the guardian ad litem, or a guardian for someone like your brother, very different than a guardian ad litem in a divorce case or a custody modification case. The guardian ad litem in a divorce case or a custody case does not get to make legally binding decisions for that child. They are, again, the court's expert there to conduct an investigation. So the investigation I hit on a little bit before. You talk a good investigation. I would think you talk to the child. You observe the child first with the parents, right? You want to see how the child and mom interact. You want to see how the child and dad interact. You want to talk to the child outside of the presence of mom or dad also.
Uh-huh.
And, I've interviewed kids at school before, and the reason that you might do that is if you think one of the parents is maybe biasing the child, and you want to talk to the child in a neutral environment where one parent hasn't brought him or her to your office or picking them up from your office.
Mm-hmm.
They're in a completely neutral environment. They're around teachers. Ideally, there's a trust factor there.
Mm-hmm.
And nobody wants anything except for what's best for the child.
Wayne, when you go in, sorry for the interruption, I don't want to interrupt your mental flow, but when you go into the school and you talk to the child, does the child get a heads up? Like when that 9-year-old goes to school, does he or she know that a lawyer's coming in to talk to them that day, or is it a surprise?
Most often they do not know.
Got it.
All right, and the reason they don't know is if the child knows, the parents are going to know. And when I do that, and I think when most guardians I know do that, they're trying to avoid one of the parents coaching the child to prepare the child. And, the parents, they're in a crucible going through a divorce. They're parenting under a microscope, and everything's being second-guessed. And, typically, I'm sure the professor might agree, I would think so, we are not seeing parents at their best.
Right.
They're being second-guessed. But when it comes to the child, the guardian shouldn't be worried about mom. The guardian shouldn't be worried about dad or offending anybody's sensibilities. The guardian should be worried about the child. And that's the beginning and that's the end. What is going to be the best interest for that child?
Wayne, we just got a real-time message from the same parent that I quoted who wrote a text last week. Listening to your comments here, she wants to be clear that in her case, her child needed someone with experience in sexual and physical abuse, and that the person assigned had no such experience.
So,
talk to us about that.
Sure. I do not have the qualifications that the professor has. And I've had cases where I am the guardian and I've expected physical or sexual abuse, or I've expected mental health issues. And in most instances, the guardian has the ability to ask for a psychological evaluation of the child, to ask for a custody evaluation of the parents and the child, where the parties are subjected to, in a custody evaluation, mom and dad complete lengthy questionnaires, different, and they're subjected to all types of tests and questionings by a psychologist, and so is the child.
You're not required to consult with a psychologist.
Not required. Mm-hmm. And one of the things that is a limitation and one of the imperfections in the system is some cases there are not the financial resources for that, and we quite simply have to do the best that we can with what we have.
Who pays your bills?
The parents.
Is it ever where the parents can't afford? I mean, does the guardian ad litem ever get assigned by the judge and the state? The state pays, or is it always shared costs between the parents?
It is. I've never had a case where the state paid. In Georgia, I don't believe that the state does. Not in a divorce setting. Now, juvenile court, where we're talking about dependency and we're talking about the foster system, that's different, and the state does appoint guardians in those types of instances.
Professor Spencer, who pays your bills when you're involved in this type of situation? Not in the custody battle, but in the foster care dynamic.
In the foster, the agency that I worked for, yes.
And is that ultimately paid by the state, or is that like
by the state,
nonprofit?
By the state,
okay.
Yes.
Got it. So we have a caller that's been patiently waiting, and I want to. I'm sorry to have interrupted you, Wayne. I just think that this will, make it a little bit more visceral. And then after the break, I'd love for you guys to share some direct personal experiences of success, because we've been talking about some of the problems in the system. But a mother writes, I'm not going to edit it. I was going to edit it in terms of the language, but I know, Wayne, that as a mature professional, I'm sure you've dealt with distraught parents, and you won't be personally offended. This mother writes, I'm sitting here, I feel like it gives more opportunities to use the children as pawns, while some BS lawyer sits back and collects. I'm sure it's not the first time that you've ever heard that type of sentiment.
No.
If there's a parent listening and is dealing with this and is feeling that, what would you say to them?
Well, so one, the lawyer does collect information, right? We collect information, we analyze it to make a recommendation.
I don't know whether she meant collects money or collects information. So, listener, if you want to clarify what you meant by that, because I didn't get but let's assume that she meant collects information.
Okay. And it's like any process, okay? The guardian's report, the guardian's recommendation is only going to be as good as the information that they have. So when we talked earlier about asking a child, who do you want to be with, mom or dad? I don't ask that question, and a good guardian doesn't. They ask open-ended questions. You don't want, I cannot imagine at my age right now, in my mid-50s, someone asking me to choose my mother or my father. So I would hate to think, and I know it happens, but I would hate to think it happens with any regularity, that a guardian ad litem does this. In Georgia, we could have children as young as 12 write elections, right, or sign elections saying which parent they want to be with. One of the first things that happens when you have a guardian, in the cases I'm involved with, the guardians say, we don't want that child signing an election. We don't want an attorney putting an election in front of that child. The election is not determinative.
Sorry for the interruption, Wayne. Just to clarify, because we're going to come up on the break here, that listener heard my question, which was in her message, did she mean collects information or money? And she says money. The lawyer hasn't collected anything else. So that's a hard. That's hard to hear.
It is, and it's unfortunate. And what her lawyer ought to be doing is asking, talking to the guardian. I always, and every guardian I've worked with, tells the lawyers that are representing mom, dad, or grandparents or another family member, if you ever have questions, let me know. Give me a chance to explain it. The other thing you mentioned
is the
briefly,
parent allowed to do that, to just reach out to the guardian?
Oh, gosh, yes. Yes.
Because what we heard in last week's program was that parents were told, maybe this is the New York context where it was a lawyer, not a guardian, but were told that they could only reach out jointly. Okay, I'm actually getting a real-time clarification. This is a New York situation where just a lawyer's been assigned to the child, not a guardian ad litem.
Okay. So that's different, right? Because with a lawyer, there's a privilege issue. And as an attorney, if you represent a client, you cannot share what your client is telling you with other people. That a guardian is different, and I may not, even as a guardian, I am probably not going to share with either parent what that child tells me exactly, because that's not going to be in that child's best interest necessarily. It may serve to drive a wedge between the child and one of the parents. I'm going to be respectful. I'm going to put it in my report possibly, right? If I have to do a report for the court, and the parents will see it that way. But you don't start with the child, and you don't stop with the child. One of the first things that a lawyer ought to be telling their client, I want to know teachers, neighbors, coaches, rabbis, ministers, priests, who is going to be able to tell me about you and your child and your relationship. I want to talk to them.
Professor Spencer, there's a quick question for you, and then we do have to take our last ad break. That there's a listener that's writing about the extent of the client set. So how many, and the fact that there's no way that these social workers can actually attend effectively to the individual clients, how many children do you or someone in your position have on their docket, so to speak? How many kids are you represented either as a guardian or working on their case as a social worker, and how do you actually give each kid the individual attention they need given the limited resources?
So as a social worker, we have around maybe 15 to 20 clients, and our goal is to see the client at least once a week. We try to see them. We see them in schools, sometimes at the home, different locations, wherever the child is. We can go and see them at any time. So, and again, we gather information and share it with the guardian ad litem. And I think even the discussion where I think the mom was asking about, she had an incident where her case was sexual abuse. The city has programs where if a child has experienced sexual abuse in any way, their specialties, like the New York Society for the Prevention of Cruelty to Children, they have different departments where the child can be interviewed by a psychologist or a licensed social worker and a professional who could also provide the reports to court. So I think maybe the resources weren't provided to the mom or to the attorney or to the guardian ad litem, where there are agencies out there and services that's available to families and to the parents, so they know where to take their child if there's a concern.
And hopefully those services are availed of by the professionals involved. We're going to, before the break, actually make a judgment call to take this caller's question, and then we can ruminate on the question over the break because of the limited time, and then come back. But before doing so, Professor Spencer, the genesis of my question was some of the research in going to the show about, I guess, not in major cities, but that there have been some district attorneys that have actually brought cases of abuse of guardianship systems, particularly in rural areas where there are less, and Indian reservations as well, where there are less resources available, and people sometimes have hundreds of clients that they're getting paid for the state private. That's probably fodder for another show. All right, caller. I hope I do this without dropping the caller. Caller on line 4, you're on the air. Let's take your question, and then we'll go to a break and have the guests think about it on the break.
Hi, it's Stan. Good evening.
Stan, how are you? Good evening.
Okay. I want to speak to, this is a question from left field, and it's to the social worker and to Wayne. How much politics is played in a lot of these decisions? You have people you have to answer to. Is there any politics? It sounds crazy. Is there any politics in any of these decisions? I know that sounds, absolutely crazy.
We're going to get to the answer after the break, but can you clarify what you mean by politics?
Well, in many cases, the state wants to see certain results skewed to. I'm not saying you do that. Let me make that clear, Wayne. But they want to see certain numbers maybe a certain way. And I'm wondering, do you get any pressure, either one of you, or do you see things like that? Maybe not for you, but from other places, from the higher ups. Okay,
that's a really interesting question. I think that I would add into that if there's a bias towards, is there a gender bias also sometimes in the?
Yeah, but I'm more worried about the the people upstairs, them putting a little pressure on.
All right, well, we'll get to that after the break. Stay with us, please, Stan.
Always a pleasure to talk to you.
Please stay on the line. We'll be right back.
The devil's right there in the details. You don't want to hurt yourself. Don't look too close.
All right, let's talk for a moment about a sensitive topic. It's erectile dysfunction. A lot of folks, a lot of partners deal with this. It's emotionally painful. Manhattan Medical, yes, based in the New York area, but available by consult by telephone to anybody in the U.S., provides a new effective therapy for erectile dysfunction. It's called GainsWave. It does not involve expensive blue pills. It's non-invasive. It's surgery-free. It's painless. A lot of folks can't take traditional remedies for erectile dysfunction due to other conditions. Manhattan Medical gives you another option. It's extremely effective, no side effects, and in the vast majority of patients, wonderful results. This sponsor came to Equal Footing through a close friend of mine who's in his mid-80s and has struggled with erectile dysfunction, and he used the Manhattan Medical's GainsWave therapy methodology with success, and it's really changed his life and emotional health. This is something that's difficult to talk about, but does affect as many as 60% of men at some point in their life. Call Manhattan Medical. Get a consult. 888-EDCure9 is the number. That's 888-EDCure9, or numerically 888-332-8739. That's 888-332-8739. Call Manhattan Medical. The GainsWave therapy could help you in your relationship. And if you mention that you heard about Manhattan Medical's GainsWave therapy for erectile dysfunction on Equal Footing, you get a free consult, which is a $250 value. So again, 888-332-8739. Operators are standing by.
I've been caught, but I'm keeping on to. And I've been told, but I'm
You're back on Equal Footing, and I'm Dove Tusman, and we're joined by Wayne Morrison, who's a family law attorney, and Professor Marion Spencer, who's a social worker and has worked in the foster care system. We've been talking about guardianship, legal guardianship for children in the context of court disputes, and our caller asked a really interesting question about the pressures that may exist in the system. Let's see. Professor Spencer, are there such pressures? Do you feel them? Just because you feel them doesn't mean you cop to them, but do you feel kind of political pressures in this world of representing children in court?
So there has been, I would say, one incident in particular where I recall being pressured to have a child remain in a home where it was not in his best interest. And when I brought in the report, like we even have reports from the school that there was a concern that it's not the best placement for the child. And when I brought it up to, the higher-ups, they were saying, well, continue to work with the foster family. We don't want to move the child again. But it was not in the best interest. Like his well-being was not cared for. He was physically not cared for. So I had to, actually this was a case where the guardian ad litem actually helped me because I presented the information and the school's information to the guardian ad litem, and she also did her investigation, and she assisted me in removing the child into a more appropriate foster home. So there sometimes are a little bit of pressure to say, okay, maybe you're digging too deep, or maybe you're asking for too much of these families or the foster families, or maybe you're inquiring too much. So there are sometimes like pressures where it's like you're doing too much.
And good for you for resisting it in that context. And Wayne, how about you quickly? We're short on time. have you ever felt kind of external pressures or political pressures as a guardian ad litem?
I have not, and it may be that I'm fortunate, but what I go back to is a judge makes the decision, and if they don't like my recommendation, they don't follow it. And I've been fortunate that I haven't had that happen, but I've seen it happen. And guardians get challenged in court, and you end up having teachers called to testify, and you end up having coaches and friends and all the people the guardian talked to and others testify in court. And at the end of the day, the judge makes the decision.
There's we just have 2 minutes left. A listener's comment brings up the last thing I wanted to say, and they say, we have so many ways to get involved in noble causes involving children. The question to the panel is, why have you chosen this professional path? Give us 30 seconds each, and us on an inspirational note. Professor Spencer.
Okay. So I chose this path. I love working with children. I have an absolute passion for persons with severe mental illness, for the disenfranchised. I absolutely love seeing the progress that persons make when society counts them out. And I work with them individually to say things can be changed, your life can change. It may not be what it used to be, but there's always like a light at the end of the tunnel. So that's what does it for me. I've been doing it for many, many years, and I plan to do it for the rest of my life.
God bless, and help us get that 6 out of 10 up to 9 out of 10. How about you, Wayne? Just super quick, 20, 30 seconds.
Sure. I have a chance to make a difference for the better. We get to deal with children and families in crises and try to help them out of it.
Thank you, Wayne Morrison and Professor Marion Spencer, being on equal footing, talking about this sensitive subject of children's representation or guardianship in court. If you're a parent and you're listening, check out the show notes. You can listen to Equal Footing on SoundCloud. Next week, hopefully, we'll talk about other distribution methods after the live programming. And you can even, I'm sure, reach out to either of these individuals or others from last week. We'll include other resources in the show notes if you're dealing with this issue. God bless. Talk next week. Thanks.
Thank you.
Thank you.
Clowns to the left of me, jokers to the right. Here I am, stuck in the middle with you. Yes, I'm stuck.